So a couple of words about our speaker today. Karen Keating Mara is a very gifted attorney who has practiced in early stage startups for a really long time. Biotech is something that she knows and cares about, in addition to lots of different kinds of startup companies. She spent many years at Safeguard as their general counsel. She peeled off to create her own boutique practice, and she does really cool stuff. And in addition to being a good lawyer with a great sense of humor, which I think the only lawyer I know that has a great sense of humor, other than my colleague Robin Sheldon, is my husband. So I think being a lawyer with a sense of humor probably goes a long way in this business. So Karen is going to spend some time talking to us today, and taking questions on what do you need to know about when you move into the adventure world of startups. So and I should also parenthetically mention that we are, full disclosure, we're friends, so I don't want anybody to think I'm just promoting a friend. I'm promoting somebody who's really good at what she does, and is very gifted and has helped a lot of companies that have had tough startups get off the ground. So with that, please welcome Karen Keating Mara.
Thank you, Donna, and I'm so pleased to be here today and part of this great speakers series. I want to thank Donna, my dear friend and professional colleague from years ago. Thrilled to be here with Robin Sheldon. I want to thank Dr. Ritz for making this innovation speaker series a continuing reality for Jefferson. I think it's a great idea, way for you guys to meet with some professionals who are in the field, in the trenches, doing the work that you may be considering doing. So just briefly, here's what we'll cover today. It's a lot to cover, so I'll kind of go through it fairly quickly so we can spend some time really having a discussion at the end and answering your questions. But I want to go through, I'll tell you who I am a little bit more, thinking about things you want to think about in terms of company setup, licensing, really what you'll get as a founder, a founding partner of a firm, and some of the basic documents you'll need to be familiar with, and then finally some common mistakes that I see over and over again in the startup arena. So as Donna mentioned, I've been doing this for a long time. I have both a financial background, which I had before I went to law school, so I went through a GE program that taught me all about finance and really understanding companies and their operations. And then I was at Drinker Biddle and some other places, including Safeguard Scientifics, where I did a lot of work with both venture capital work, working on the fund side, as well as on the company side, as we invested at the time in the late 90s and early 2000s in 15 companies a quarter at times. So we had a lot. And then, unfortunately, after the internet crash, I had to take them all apart. So I kind of got a really good view of the whole life cycle of a company. And then, as she noted, I started my own practice in 2005 and represent a lot of life sciences companies, many of which come out of the tech transfer arena from various universities in the city, which has been a lot of fun, because there's really nothing, for lawyers who we could kind of get lost in the details, and we have to be mindful of all the legal ramifications. It's really exciting to be a part of innovative technologies and life sciences approaches that can really change the world. So it's a great place to practice. So when you think about when you want to think about setting up a company, it seems like there's some common motivations to do it. One would be, of course, to apply for grants, the SBIR grants and its corollaries in the various funding arenas. And then there's a lot of foundational grants that will also only allow you to apply for grant money through an entity as opposed to your university. So that's a lot of my clients will start out with that being the goal, that they have a project that they think is ripe for SBIR funding, and we need to start a company. So how do we do that? And then secondarily, a lot of folks in the university arenas do consulting. They are experts, as you know, in your fields. You will, for the medical students here, you will become those experts as you grow in your career. And having a company between you and your third party can provide you with some protection. And really, that's why companies exist. They exist to provide you as an individual with protection against liability. That's really the whole purpose of having a corporate entity, so that your actions as a member of that entity or an officer of that entity are protected as long as you follow certain corporate procedures from any personal liability. So your personal assets are protected. And so that's a reason to start it up. And then again, as a mechanism to grow and to launch a company that really could become something quite large in the future. You have a couple choices at the outset. There's C corporations, S corporations, which are small corporations, and the limited liability companies. The main point you really want to consider at the front end is where are you in terms of your technology. If it's am I loud? As you know. Sure. You need to decide on the type of corporation that's right for your enterprise at the time you're doing it. In rare instances, you may have something that's really like right on the cutting edge, and there's funding coming out of venture capital firms all over the place, and in that fairly limited circumstance that exists, you may want to go right to a C corporation and file. Typically, you'll do a Delaware corporation because Delaware Court of Chancery and the Delaware other courts have the most established case law and statutes in the corporate arena and are relied upon by many, many investors around the country. So if you're going to bring investors in from outside of this area, they like the certainty of a Delaware corporation and the laws governing those entities. But when you have a C corp, you have double taxation, and so and you don't get the benefit of taking advantage of your early losses as an individual investor. So it is not, while there's a whole set of documentation that are really standard in the VC community, to do your stock purchase and your various rights agreement and stockholders agreement for a C corp. A very early stage company where you have essentially a little more than an idea that you're going to seek funding for to develop, to get to prototype, you're going to get taxed on your salary as well, and you're not going to be able to flow through your losses. They're going to just continue to accumulate, and they'll be utilized hopefully in the future. But it's not an entity I see much of in the last 10 years for new startups. Most of what I see is the use of a limited liability company, which has a lot of the same attributes as a corporation from a liability protection standpoint, but it has more flexibility as well because in it, the statutes in Delaware, which also has a very robust code in this regard and case law, as well as Pennsylvania, frankly, though, as well, for locally based companies. The way the code is written in these jurisdictions, they give you kind of guidelines. I mean, there's certain things you have to do, but by and large, you can decide by contract how you want your company to run. You're not wedded to corporate law as much as you are with a C corp. And so you can have an operating agreement, which is what the governing document is called, to figure out how you want to work, how you and your partners, your founders want to work, and how you're going to manage your company. So it provides a lot of flexibility. But in terms of the choice at the very front end, the great thing about it is that you get passed, if you elect to be taxed as a partnership, which the vast majority do, your losses are flowed through each year. So you get to take advantage personally of any of the losses that you accumulate on a year-to-year basis. And many early-stage angel investors really appreciate this form of investing. And that's relatively new, I think, over the last 10 years. But I've seen that most of them are actually want to see, they'll still do C Corp investing, but they like the fact that they get immediate for their investment. They're going to participate in the accumulated losses each year on their tax returns and get that benefit, that offset. So governance, you'll have to think through governance issues, and this is one where, certainly there are LegalZoom, and you can go online and you can file for any of these things. Anybody in this room could file to be a corporation or file a certificate of formation to be an LLC. That you don't need a lawyer for at all. It's the governance documents that get a little more tricky, in terms of, well, how do we operate this company? And in the limited liability company, where in most states, you don't have to have an operating agreement. You can do it by verbal agreement. That's never a very good idea, as you can appreciate. Once you get into that, it's probably time to talk to someone who can help you think through all the various issues about how you want to manage the control issues in your company. So once you've set up your company, you've established your company, and once as I noted on the slide, you got to start paying for it. Like the minute you file, you're on record at the states. You're going to have annual reporting requirements. They're not terribly significant, but when you're self-financing, everything matters. So I mean, you're talking about a good $1,000 a year once you file for a new company. just to keep it alive between your tax returns and your annual report filings. So once you decide to do a startup, well, how are you going to pay for it? Who's going to pay for it? So you really do need to think through who your initial funders are going to be. And then typically, it will be you for kind of the initial setup cost and maybe some initial office or other resources that you may need that might be outside your work here at the university. So once you also need to think about maybe a little longer term about, well, who would be interested in financing that, and who is this technology or compound or whatever it may be, who is it attractive to, and where are the funding sources in my network, to kind of have a plan, because you really do need to plan for this because it's hard to raise capital. What I've noted here is in terms of how, the first question is who's going to finance it. The second is, well, how do I account for it? In an LLC agreement, for instance, you can do it as a contribution to capital, which is essentially equity, or in a corporation, that would be stockholders' equity on your balance sheet. Or you can, as a founder, you can advance the proceeds as a loan. So as you raise money and get money in, you can get paid back. So it's really, if you contribute it as an equity investment or as a contribution to capital in an LLC, that's it. You're not going to see that for a while. If you want to have more flexibility, if you personally can't weather that, you'll make it as a loan and make sure that your accounting is set up to reflect that. So if you're doing a company based on the technology you've developed here at Jefferson, you've got to figure out, well, who's going to own what going forward? Because as part of the technology transfer that you'll receive, your license, there's going to be participation by the university in your company. And so you're going to have to be comfortable with who's going to own what. And be aware of that, even though you've created this technology, if you're going to be the licensee and be the CEO who's responsible for commercializing this particular technology as you go forward, well, you're not doing that alone. You're doing that with the technology you've developed here, and Jefferson is going to participate in that. And so it's good to just be mindful of that going forward. You probably all are familiar with your patent policy, but I still find entrepreneurs are often reluctant to give up a piece of the company, but I think one of the things to understand at the outset is that a great idea that goes nowhere, is not worth what you think it's worth, and that you're going to have to be comfortable sharing parts of your company with third parties who are going to help you grow it. I see this a lot. There's such a reluctance for founders, and I understand it. They've built this; it's their baby, but you need financing, you need professional help, and you're going to need partners to grow something. So it's good to be mindful of those. And once you get to that point where when you're going to start to think about a technology transfer deal, you're going to have more documentation. And so these are the things such as you're going to have to start using organizational minutes and consents. You're going to have to build a corporate record of what you're agreeing to do, consistent with your organizing documents. There'll be subscription agreements you'll need if anybody's going to join your company, so you can document who's purchasing what interest and for how much. And then one of the things I often recommend is that everyone get a good accountant right at the front end to help you, because all this will be fed into in an LLC environment to K-1 tax returns. But otherwise, you want to have a QuickBooks or Quicken or something that is accounting for all your investment into the company, so you get credit for it in your financial statements, which are going to be part of the diligence phase as you go forward to raise money to grow your business. So when we just a few things about your technology transfer deal to keep in mind. And this is something that a lawyer can help you with, and you should be mindful of when you're speaking of that with one, is that I've found that oftentimes you can want to utilizing an option agreement as the first stage in deciding once you've formed your company to commercialize this particular technology. If you're able to, perhaps you want to pursue an option agreement with the university, so that you can have a little more time before you are officially their partner and have obligations to them to decide if you really can get this off the ground. Can you put together the team to take this technology to the next level? And that's going to be finding other collaborators, finding a business development person to help you make connections in the angel and venture capital world. And understanding the marketing and the marketplace in which you're operating, and understanding the terms of the deal that Jefferson's going to require, or any university, frankly. And these are, while there's certainly lots of ways of doing it, I would say all universities, when making a technology transfer, are going to want both there's going to be a royalty component of your license agreement and an equity component of your license agreement, and then a myriad of other terms, and the third thing would be patent reimbursement, too. So those are the three kind of fundamentals that are going to be in every license agreement. And it's good to understand those so that you understand that, so as the university is going to participate both in the cash that's generated through the royalty, or could be on a net or a gross basis. They're going to participate on an equity basis, which will help them participate if there's an exit at some point. And then they're going to want their costs back because they have incubated all of this technology. And so the costs that they've expended in patenting or even evaluating the patentability of your particular invention is going to need to be reimbursed. In terms of some of the other things I want to think of, too, is the field of use. In most cases, you're going to get a very broad grant to the field of use, meaning you'll get a grant to this, patent portfolio for all uses, for the most part. But it depends. It depends on how broad that may be, and you want to be mindful of that because there may be the university may want to bifurcate that and give you. I've seen it at a university in town where there was one set of patents. Somebody got orthopedic, somebody got neuro. They really did. Delineate the field of use very specifically to a number of different companies, which created some confusion among the collaborators, but it's how the university wanted to proceed. So how much equity? And this is really just to give you an acclimation to what you'll be experiencing. I would say in this market, and this happens nationally, but in this market you're going to see anything from as low as 5 to 10 to a high of 50% of the equity of your company that the university is going to want to have when you set it up. So they're going to truly be your partner. It ranges based on what the stage of the technology, and different universities obviously have different policies. Some deals will require that once the university gets their equity grant in your company, that they have something called anti-dilution protection, which means that if you issue additional equity to other parties, like a CEO is going to want, depending upon where you are in your stage, you're going to want 5 to 20% of your company, if you don't have cash to pay them. Well, that's going to be a dilutive event, and if that's not carved out, you're going to have to make your initial grantee of the university whole. So you're going to have to give them more shares to keep them at their percentage level. So anti-dilution means they get to stay the same to a certain point, which means you guys as the founders, you're getting diluted. So you just have to everything is kind of a zero-sum game in that regard. The founding members who have the vast majority of the ownership at the front end are going to get diluted. And some of the original parties, like the universities, are going to be kept at a stable level for a certain period of time. Usually, it's through a certain funding threshold or funding event. It could be a milestone. It could be a technical event too, but mostly it's funding. You'll have to be aware of too at this point that there are things called preemptive rights, which means anybody who is a member at the beginning or a shareholder is going to get the right to buy in future offerings their percentage interest so that they can keep themselves whole, but by writing a check and not just getting it automatically. You will also likely see terms that are we refer to as co-sell rights and drag-along rights, and voting agreements, which are in your shareholders agreement. These areas really relate to, okay, once you've got some funders in your company, how are we going to work together? And whoever's put the money in is going to want to drive the ship for the most part. And so if someone has put a significant amount of money in your company, a venture capital firm, for instance, they're going to want to say, well, if we find a third party who wants to buy us, or we want to sell a significant portion of our assets to, we don't want to have to mess around with asking for your consent. In a drag-along right, you're agreeing at the front end if a transaction meets certain criteria, it's approved by certain members of the board, or a certain number of your shareholders agree for it, minority shareholders are preemptively or prospectively agreeing to go along. So they're being dragged along, and that's to get around some minority rights issues that emanate in Delaware law but are reflected in the statutes of most states, and some limited liability codes, but not all. Co-sale means if you're going to sell your stock to somebody, they get to come along with you. So it's really a matter of, so folks who put money into your company want to make sure that you can't exit later without them. That they can bring you along on an exit, and that if you're getting out, that they have an opportunity to participate in that sale too. That's pretty deep dive stuff, but being aware of those terms are helpful, and you can find commentary on the internet to kind of get you more familiarity as you move forward with that. But if you're talking about co-sale rights and drag-alongs, you will have a lawyer with you, I'm sure. Royalty rates, again, just depend on the industry. You know, they're not, it's not one size fits all, so it's worthwhile to have someone in your team who's business development oriented, who can give you some guidance as to what's standard for the field of use in which you're going to be operating, or your primary market. And then there's some things in your license agreement you need to be careful, or you be mindful of, that you have a royalty rate. But if you have if the technology you're licensing is only one part of what's going to create the product in the end, you're going to need to in-license technology from other third parties, you'll want to have something called a stacking provision or a combination provision, where the net royalty to the university is reduced to a certain level to account for the fact that you don't want to have, you could get yourself to a point where your royalty rate, your overall royalty rate to third parties could be quite extreme. So that's something your lawyer should help you walk through, so you're not just, if you say your royalty rate is 5% of net sales, and you have to do 2 more of those deals, 15% of your net sales going out the door just as at the starting gate is tough. And ultimately, it would be better for the company and the shareholders, the other shareholders, if you're able to minimize that to a certain extent. You want to think about your ability to sublicense. That'll have slightly different terms. And what fees are embedded in that. And this is an area where I think a lot of entrepreneurs, I find, get a little bit surprised. And in addition to giving, a significant, well, I guess a nominal to significant, depending upon the terms, equity piece to their university, the royalty rate, and the patent reimbursement costs, there are also some fees embedded in the document, or, that may be based on when you pass an FDA milestone. So you just have to kind of make sure you have some financial person, if it's not you, really figure out this and build it into your model, because I think that's where it gets a little challenging, is that you want to make sure you can really model this license agreement for what you want to do, so you can plan accordingly and you're not being reactive as you move forward. So as we talked about equity before, in terms of what happens at the front end, and when you start a company, is typically the founders will own all of the equity. You could, it might just be one person, and as you bring in folks, they will dilute you, and you will have overall a less percentage interest. Then we have the university coming in, that will change. So the founders, the initial owners, will always be the subject to significant dilution. But if you're continuing to operate in the company as an officer or a director, you could be, and you should argue or negotiate for, to be eligible for additional grants under equity compensation plans that will likely be put in place at the same time you do your first round of funding. Equity compensation plans are put in place at most companies to give key participants an ability to grow, share in the growth of the company from an equity perspective. They're an exemption from securities laws. You can't, as we'll get to in a moment, you just can't issue equity to everybody or anyone without really thoughtful review. The one thing that I often caution clients about and founders is that you at the beginning of your company, you will be giving out equity to various folks because you don't have cash. So you're really using equity as a compensatory mechanism. But not everybody works out. In fact, more often than not, folks don't work out. And so it's as difficult as the conversation may be, it's very important to build in clawback provisions into your operating documents, so that if someone were to leave, first of all, they could be subject to vesting. So you get an interest, a stock option, or a restricted stock grant, or a profits interest, and it's subject to vesting. So if you don't stay and you don't perform, you don't get. And even if you leave, there's still a mechanism for the company to get it back. If you get fired for cause, typically it's for a nominal, if no value. And if you're terminated without cause, a lot of times there's a mechanism to buy it back at, quote, fair market value, which is determined by the board typically. And then you get a note. In most cases, most equity compensation plans will have a provision where they can utilize a promissory note. So It's very important at the front end for founders who may not be, you're not at that level yet where you're going to have a plan, to make sure when you make a grant to anybody, even if it's a partner you've worked with for a long time, you have an agreement amongst yourselves in writing on if you don't do what we say we're going to do, you get the equity back for redistribution to other key contributors, because otherwise it's really a mess. And I've had many companies where we've had a wayward founder we can't find anymore, so you can't even find them to get their consent, or they won't give it up, and then you have a change of control transaction, and it's a problem, because if you can't get a certain consensus among your shareholders for certain change of control transactions, and they don't, that can really queer a deal going forward, depending upon how many and what their interest is. When you have a company that you founded and you're a scientific founder, you may continue to work, first of all, just for sweat equity, for the equity interest in which you have. But if another third party is a significant player in that, you may also be able to negotiate for consulting fees, on an hourly or per day basis. But it's something to consider depending upon what your role will be or what your other obligations are here at the university. And that's always important to manage, what your expectations are for the company and what the expectations are here at the university. Because depending upon what that is and how, will depend on what you ultimately get. Because in most universities, when the founder isn't day-to-day, and may have an interest, but maybe not a significant interest in the company, they will get compensated for the success of this company through the patent policy, where everything the university gets is split, in terms of the cash and the equity. Ultimately, you as members of the university will share in that. In the alternative, if you are going to be a significant holder in the university, you may be waiving those rights for having a significant equity interest and control position in your company. And those are, depending upon where you are and what your department's doing, you do need to think through all those choices at the front end as to what makes sense for what you're going to do, what time you have to dedicate to this, while you're being compliant with all your other obligations. And in terms of tax implications too, this is something to be mindful of too, where if you get an interest in a company when it's first beginning, there is if you're a founder, there isn't a tax implication. Your basis is essentially, but your basis is nominal. It's whatever nominal purchase price you may have paid, or the par value of the stock, if it's a C corp. Going forward, though, the company will have to make valuations of its company on a per share or per unit basis to determine what is this worth. And if you get a grant at some point in the future and the company has some value, you're going to have to pay tax on that. So you can't get additional grants except for certain stock option grants in a C corp. And profits interest in a limited liability corporation. But I guess the point I'm making is simply to be mindful that when you receive stock, it is a transfer of asset from the IRS's perspective, and there are certain exemptions to get that on a tax-free basis, so the event of getting the stock isn't taxable. It'll be taxable in the future, and you have to be careful about that, because if you do it in a way, if you just issue shares, putting aside the securities laws issues, if you issue stock after you've got some value and you don't make an 83B election, or you could end up paying a lot more tax and have a lot more or a lot less return on your interest than you may anticipate. So it's also very important, in addition to having an accountant who typically would be your tax preparer, to really make sure before you do anything, you want to check with them about what's the most tax-efficient mechanism. And again, as I mentioned earlier, in most cases, once you start a company and you have some funding, part of that funding will be establishing an equity compensation plan, and that will be the mechanism to get you additional equity grants. If it's appropriate, if it's a C corp, and you're an employee, you can get an incentive stock option, and that's great. And if you're in an LLC, you can get a profits interest grant, which is also a very tax-efficient way of getting you value, and you're giving you a way to continue to appreciate in the growth of the company. So, common mistakes, and this is an area where I spend a lot of my time, where when you're in a startup mode, you're doing everything. You're doing the research, you're paying the bills, you're trying to find the investors, you're trying to find the collaborators, you're trying to interest pharma. It's a lot to do. And you just, I think intuitively, when there isn't a lot going on, people think you can just, okay, I've got equity. I can give it to you. If you do this for me, I can give you equity if you help me out. I'll give you a consulting agreement. I'll give you X percentage, to participate in the company. And a lot of what I think folks forget is that getting an interest in any company, whether it's a stock option, stock itself, a membership interest in an LLC, a profits interest, it's a security. And there are laws both at the federal and state level that govern securities. And basically, under the set of laws that came in play in the 30s, you can't issue stock in the absence without a registration statement in absence of an exemption. And so every issuance of stock that you ever do has to be cleared, has to have an exemption from registration on both the federal and state level. And I've run into a lot of early stage companies who've, they've been going along on their own and they come to see a lawyer a year or two down the line and they've not done that. Particularly, even companies who might have had a lawyer at their first financing, and then they keep issuing stock or convertible notes because somebody else wants to put some money in, and they just don't remember this. And it can give rise to rescission rights and other bad, aside from the fraud aspects of the securities law, you can be subject to rescission rights of the holder, which can be a mess. And from a diligence perspective, you'll probably be in breach of many of your agreements, because every agreement, once you're funded, every agreement you have with a third party who's putting something into your company is going to make you say, on behalf of the company, that every security ever issued by this company has been done in compliance with all applicable federal and state securities laws. And that's that part of the document that nobody ever reads. The business folks tend to kind of glaze over, but it's a big deal. And it could really, Google had a huge problem with this when they went public. And they were able to fix it because they had done it too. So it happens like all the time. It is very common. But my point is to be mindful of the takeaway for you is to think about any time you're issuing an interest in your company, you really, except for the day you file. When in Pennsylvania, I think you can issue up to 4 or 5 people within the first 6 months of registering, and that's a founder's exemption. I think there's 23 exemptions under the Pennsylvania State Securities Code that I'll check for a client when they want to do something to say, okay, can I fit it into one of these exemptions without making a filing? There are always there are always ways to do it. You can file a form with the Securities and Exchange Commission called Form D to register an exempt transaction for private place. It's basically a tool for private placements. We'll put the public on notice that you're offering securities, and you tick off the box as to what exemption you're relying on federally. And typically there's a state corollary that'll just require that to be filed. But you have to do that within 15 days of when you sell your first security, usually both federally and at the state level, and you've probably got to write a check. Pennsylvania's tough. It's like $525. Yes? Yes. Yes. So the question is, I mentioned that someone issues a convertible note without thinking about it. A convertible note is a security under the law. A lot of folks don't think about it. They think it's just a promissory note. But even a promissory note that has some convertible elements, there's a whole line of case law of whether is a note really just a note. If it has some control provisions, if it isn't simply a note for a period of time at a fixed interest rate, if it has any other bells and whistles, it could be viewed as a security under either state or federal law. In the early stage funding arena, it is absolutely a security. It's because it's convertible into, and I should say, a convertible note, which is the mechanism that most startups in my practice, and in the last 2 years, I've probably done 10 deals, and only 2 were stock deals. They were convertible note deals because they were very early stage. Post-founding, we had the founders fund, self-fund. Then we did a convertible note round, which means we offered to investors promissory notes that converted into the equity of the company at a future date. And it's tied to, the reason for it, I guess I should go back and say, is that because when you're early stage, it's virtually impossible to come up with a real valuation. who knows what your company's worth? You're going to think for some reasons, you're going to want it to be really high. For stock grant reasons, you want it to be really low. And you have really no comps. You have no numbers. So it's very challenging to come up with a true valuation for a company. And when you issue stock, you have to decide, well, what's the price per share? So to avoid that issue, and really founders find that they need a certain amount of capital at the beginning to kind of get the technology to a place where they feel like that really could be more highly valued. You'll do that through the use of convertible notes. So it's a promissory note with an interest rate. It might be secured by your assets, it might not. And it will have, you can make your maturity, your term, for a period of years on demand, or some variation thereof. And then within it, it'll have provisions that say if you do an equity financing in the future of at least a certain dollar amount. So recently, all the deals I'm doing recently, it's $2 million is the threshold. So if you raise $2 million from some third party or parties, we will convert, this note will automatically convert into whatever you issue to those folks at a discount. And that's anywhere from 10 to 30%, but 20 is pretty standard. And that's what I think Ben Franklin uses and some of the other funding sources in this market. So you build it in. So these folks who are giving you their money now have a note, so they sit on the balance sheet ahead of equity. So if this thing goes south and there's anything left to monetize, they're going to get it before you do. But if you are able to successfully raise money in the future, they'll say, I'll go with them. I'll agree to that third-party valuation, and I get, because I'm coming in early, I get a kicker of a discount. And that's how so it is a security, to answer your question, because it converts into the equity of the company at some point in time. Most of those notes will also have features where it's a mandatory conversion if you hit that funding threshold. There's an optional conversion if you raise some money, but not quite that much. And then some of them will build in also a backstop saying, well, I might want to just convert into common stock or the LLC equivalent at any time or from time to time at a fixed valuation. And that's where you're throwing the dart at the wall saying, okay, at any time I want, I can convert at $5 million, at the value that on a per unit or per share basis, at a $5 million pre-money valuation. And so that you do the math, it's not that hard. You figure out how many shares or units do I have outstanding, and you divide by 5 million, you come up with a price per share, and you divide your principal by that amount to come up with the number of units that this person will get. So it's a little bit of a long-winded answer, but that is the mechanism most early-stage companies get funded. And even, as I mentioned, Ben Franklin Technology Partners, they utilize a note with a conversion feature. All the Ben Franklins are a little different in each region. They'll also get a warrant which is like an option. If they don't convert, but it's a note, so it sits on the balance sheet. So the bottom line takeaway is if you're issuing stock, you should talk to a lawyer to make sure that there's a proper exemption from registration, and you've kind of created a good trail of for everybody who owns an interest in your company. Well, how did they get it? Because when you get to a great exit point, or someone wants, a pharma wants to make a tremendous investment in you, there's going to be due diligence. They're going to dig into all this stuff that you didn't have time to think about and might not be right, and that can really slow down deals. And I saw recently with one of my clients, they've been around for a while. They're on their, we did a Series C, but they had Series A1, A2, B, and we did C, and they have warrants to all these different people with your options, like commercial banks, this person, founders. It was such a convoluted cap table, so they went to a crowdfunding entity, Circle Up, which is the one, and they just said, no, it's too complicated a story. We're not doing it. It's because they have to make anytime you sell shares to someone, you're making representations that have to be true. And true meaning they have to be accurate, and you have to include everything to make that statement true. So you can't leave something out and just say, oh, that particular statement's true. You have to include anything that would clarify the statement so that it's true, because there's significant liability under the federal securities laws for misstatements in any securities document or offering document, which includes all these what we're talking about here are private placements, and they're all subject to securities laws. So from a diligence perspective, it's really important to do this right at the outset and make sure that you can show a clean trail. I think this is true for both your securities and your IP. I mean, you've got to be able to show a really clear paper trail of what you've issued and how. From a securities law position, how was it exempt from registration, and how did you comply? And from an IP perspective, who owns it? And do you have all the rights that you need? And do you get assignment of invention agreements from all your contributors, from everybody who's ever touched it? And did they have consideration? Did you do it at the right time? Those things I think are the most important. And I know oftentimes they're not, and it causes delay and expense, exponentially more than it would have cost to do it right at the front end. I mentioned this earlier. I see this with a lot of folks. Everybody, when you start a company, with your partners, it could be your scientific partners, it could be you and someone else who's bringing maybe a different skill set to the table. Everybody has the best of intentions, but people's lives intervene, and their ability to perform based, on mutual expectations often is different. So I think it's really important to make sure that there's always a way to get your equity back, because you want to try to have as few, generally speaking, you can't always do this, but you want to have as few people who own your company as possible. Like, it's unwieldy to manage, consents and shareholder issues, or the corollary in the LLC environment, and it gets unwieldy from your cap table perspective. A cautionary note, business development people who are folks who are saying, oh, come join me, or hire me, give me a big slug of your company and I'll get you money. They never can. They rarely can. I'll say they rarely can. Honestly, it's shocking how confident folks will be at conferences that we all attend, and it rarely happens. And meanwhile, you've entered into a consulting agreement with them, and you've given them 6% of your company, some of which is vested up, even if you had vesting, some vested up front, and they don't deliver. What do? Now you're stuck with this guy who's going to, or girl, who's going to participate in your upside if you're able to redirect the company after they leave. That happens a lot. So you have to be really a little bit Machiavellian at the beginning and just look out for the interests of the company and make sure that you can get back your stock that you grant to folks if they don't perform. And you have to be really mindful too whether you engage someone as an employee, or you employ them as an employee, or you engage them as a consultant. You have to be able to be hard when you're coming up at that first vesting tranche. Are they performing or not? And if they're not, you got to cut the cord. And that's hard because obviously there's relationships involved, but otherwise you're stuck. And so early is always better in terms of that. I alluded to this earlier too, and failure to manage IP issues is something that I see a lot. I can't, especially once you've formed a company, and delineating what you do for the university, because that has a clear path upward to the university, and they have the right to control. It's the destiny of that IP, and it may be based on it may or may not, depending upon the terms of your license agreement, be included in your license agreement. If you continue to work in your lab and develop things, it may be a separate patent filing, and it may not be covered, depending upon what you negotiated in your license agreement. So when you're thinking of going back to the license agreement part of our discussion, you really have to think through what you think you want to do, how you're going to do it, and what you're going to need, as well as what your plans are for research and development here or in your lab, and whether or not you want to try to get more, or have an option for any additional IP that comes out of your lab as a part of your license deal. But more importantly, again, it has to do with making sure everyone in your company who touches the development. And this is, I have these clauses in basically every agreement with an employee, even in finance, even though that's arguably not as relevant. But you'll want to have in any consulting agreement, well, let me say, any offer letter for someone who's going to work for your company, whether as a consultant or an employee, should say the offer is contingent upon the execution and delivery, of a form of confidentiality and assignment of inventions agreement. Because you want to make sure the stuff you're working on is kept confidential for patent purposes and marketing, and commercialization purposes. And you want to make sure that anything they create on your dime, and using your stuff, and for you, is yours, is your company's. A lot of time, if it's not, the law doesn't think that it is. And I think that's another misconception that a lot of folks have, that they figure, oh, I work for the people who run companies, young companies, think, oh, well, if they're working for me and I'm paying for them, I own it. You don't, unless they agree to it. You need an assignment of inventions. You all have that, those here at the university, either by virtue of your employment status or your student status, it's implicit in your agreements here. So the company, as a company, you need to do the same thing. So that's important.
Is that important for outside contractors, even if they designated as work for hire?
Yeah, well, I mean, that would be part and parcel of it. So you want to, when you do an engagement with a third party, you'll want to make it explicit that it is work for hire under the copyright laws, and if it's deemed not to be, they're irrevocably assigning it to you by virtue of their agreement. So you have this agreement. Anything you contract for has to have consideration. So in consideration of the consulting fees or whatever equity grant or whatever it is you're giving them for their services, they're giving that to you. But yes, that language is important for all your third-party contracts as well. As an ancillary note to that, I would say that it's also important to think about, and I just saw this recently, a pharmaceutical company in this area in a non-disclosure agreement, which is basically a confidentiality agreement. You're basically, when you're thinking about going into a relationship with a third party, whether it's someone who might do sponsored research with, a pharma, anyone. A lot of times what you'll do is you want to exchange a certain amount of information to make sure this is the deal this is a company you want to work with and you can come to terms. So you enter into a non-disclosure agreement, which basically says anything I give you, you can't use for any other purpose but to look at this deal. And a couple limited exceptions, carve-outs. But one of the statements in there is that you want to just make sure that everybody acknowledges what yours is yours and what's mine is mine. There's no transfer of rights. That you are going to keep it confidential. But what I wanted to share with you is that I saw in one pharma, they said, oh, and by the way, even on an NDA, if anything that, that relates to something any data that may come out of this little exchange, we own it forever. So it was saying, even in the NDA, and this is it was extraordinary. And my client wanted to sign the deal with them really badly, but it was crazy to me that in a non-disclosure agreement, you don't have business terms, you haven't even agreed to work together, and they're saying, if you utilize any, not the confidential information, but any of our data the data that was being mutually reviewed, and I'm not stating that quite correctly, but in the NDA was this little clause that said, oh, by the way, if you do something that isn't confidential information, but is essentially something we discuss, it's ours forever, and you won't contest it. And it was just this one sentence that was like a bomb. I mean, that could be if in the future this company, because this whole arrangement was the small client saying, here's my proprietary process. I'm going to show it to you, and by virtue, you're going to look at, your data's going to run through this as to evaluate whether we're going to do this deal. And they were saying, well, once we do that, if you do any more of that, it's ours. You got to be really careful. So in NDA, which makes people's eyes glaze over and they think they're all the same, you have to read them carefully, because it can impact your intellectual property rights in the future when your thing becomes this huge success and somebody who has a ton of resources to throw lawyers at you says, nope, we had this agreement, that's ours, and you have to fight about it. This is one that I've spent a lot of time dealing with at the end of this past year, which is you have some initial funding and you need people to do work for you, and whether it's on a consulting basis or an employee basis. But first, as an employee, you need to pay someone, and you say, okay, I'm going to pay you $50,000 a year, and you're going to pay you $60,000 a year. So you kind of come up with what you think are really reasonable salaries for the character or the type of person and the experience they have. But you haven't really run the numbers, and you have a contractual agreement to pay someone a certain amount of money in a year, and you run out of cash because it happens all the time. Things cost more, and you're paying for your lab work because that's what's most important. So the folks that you've hired to do this are happy to work for, they're in, but you have an issue because you've agreed to pay them money, and if you don't pay them what they're owed. Within a certain, by year end, and there's a little bit of a period of 2.5 months after year end. Anything you're owed for a prior year has to be paid within 2.5 months of that prior year. You've now just tripped into this morass called Section 409A of the IRS code, and it basically is saying you're deferring compensation. You're not paying tax on it. even though you don't have cash. So you're not, it's not as though you're paying someone and you're not withholding taxes. You're not paying someone because you don't have any money to pay them, but they're still working. And that's something that happens in the early stage environment a lot. But by virtue of doing that, you trip into both this IRS code problem, which is a big problem because there's a 20% penalty on both the company and the recipient if you do this, and interest and penalties, other penalties. And also labor law. People can't work for free. Employees can't, you have certain requirements under the labor laws about what you have to pay people. So I raise this because I think everyone in the early stage environment is kind of, is very enthusiastic and is happy to not take some pay for a while if it's going to get you to the next level, but you can't cross over a fiscal year without modifying your agreement. And better yet, at the earliest stage, don't agree to pay people unless you have committed funding, I guess is the bottom line. Once you've gotten funding, make sure whether it's in your proposal to a grant or through Ben Franklin or with your angel investors, or you really line item your salary and you don't view it as optional. Because I've had recently a couple CEOs who really thought they were doing the right thing for the investors by not taking the cash and redeploying it. They had cash. They redeployed it to something else. Well, that's not, the IRS isn't interested in that. They're saying you just tripped. So now there is an exemption for that called the going concern exemption. So you can kind of say, if I would have paid all this, my company would have gone under. But you'd rather not have to deal with this. And again, as I mentioned before when I said that every time you enter an agreement for more funding in the future, you're going to have to represent to that new party, everything I've done before I did right. It's the same thing with taxes. Every agreement you ever sign for money is going to say, I've paid all my taxes when they were due, and I'm current, and I've done it in compliance with the laws. Well, this is an area where if you do it incorrectly, you're going to have a diligence issue. You might be in breach. So I like to say to early stage clients, folks who are in this at the earliest stages at the founder level or the initial contributors really ought to be working for their equity. That should be their compensation by and large, or you get consulting or consulting fees, and they're truly consultants and not employees, or you're paying them as employees at a very basic level. But mostly don't agree, I guess the takeaway is don't agree to pay people with money you don't have in writing. Because once you have a binding contract, this 409A issue can happen. Another common mistake, very common, is paying full-time contributors as consultants. Everybody in the early stage world, nobody's an employee. Everybody's a consultant, right? You outsource everything because you're one or two folks. You're trying to do everything. Well, you can do that if these people you're hiring are bona fide consultants. And there's a 20-point test that the IRS has as to whether you're really an employee or a consultant. And if you've messed that up, you haven't made withholdings, you haven't paid Social Security for them, there's potential liability and, again, a diligence issue. So the IRS not so much in the early stage space, but I know in New Jersey, they're getting a lot more active in looking at companies with contractors and no employees. Their Department of Revenue has gone after a couple companies that I'm aware of for mischaracterization of folks. They tend to be in the service industries a little more, but I think it's important to think about here too, because I don't see clients being mindful of this. Everybody thinks you can just be a consultant. If you're a consultant, some of the key characteristics of that is that the consultant isn't told what to do, when to do it, or how to do it, and doesn't have to do it at a certain place. They really are, and hopefully they have their own company, they have insurance, and other clients. So if you have those, if that's who these folks are, you're good. Don't worry, they're properly consultants. But in most early stage companies, that's not the case. And so you have to be just mindful of how am I characterizing the folks who work for me, and is it proper? There, as I noted, under the Department of Labor, you can get around this by. The way I recommend for clients to get around this if they've already tripped into this or mid-year or they're anticipating this, so you can hire folks and pay them the minimum amount to be exempt under the labor laws from overtime requirements, which is $400 a week. And then there are bonus mechanisms you can build in that are not subject to that. And also, you have to be mindful of 409A in that area too, but you'd have to have certain triggers, because you can't have bonuses payable after 2.5 months after the fiscal year ends as well. But that's something I wanted to leave with you too, is just to think about when you're building your team, are they, and this could change. At the front end, maybe they truly are consultants, but as folks begin to spend more and more time and you're directing what they do, and they're doing it mostly for you, you need to transition from contractor to employee basis. And some folks don't like that. They want to be contractors. But you have to, I think it's important to think about and to plan, again, in your financial planning, as you do your budget, to really make sure you're accounting for those things appropriately. Oh, yep. The question was, where do summer interns fit into that? Well, I mean, that's an area, too, where there's been a lot of scrutiny over the last few years by the regulators. As a summer intern, if there's a true learning component to their exercise, if it's if they're not replacing a job, they're not doing work which would otherwise be paid, it has to have that's at the highest level. There's some more criteria. It's okay. I mean, and certainly ones run by academic institutions, people who have programs are being very mindful of that now. You're welcome to have an intern, but you can't have folks, you can't have your person who's your clerical person be an intern and all they do is file, or all they do is, your scheduler, something really menial work that's got no educational component is not going to fly. If it gets looked at, and they could sue you later for back wages, and plaintiffs, lawyers, and class action lawyers, not that class action is really applicable in this environment, but they love that stuff. Yeah. So here, this just as or kind of a recast. When you start a company, if you're going to have an articles or certificate of incorporation, depending upon if you're going to be a C corp, depending upon in which jurisdictions in which you file, or a certificate of formation, articles of formation for a limited liability company. For a corporation, you'll have bylaws, which will say when meetings happen, how you have to notice people, how often you're going to do that, and certain other kind of more mechanical procedural things. In an LLC environment, it's an operating agreement. And that can go into a lot more detail. That's kind of, an operating agreement takes what, in the venture capital space, you probably have 5 documents, and it's like 1 in an LLC. And it's like, because they can be up to 60 pages long, because they take over the role of something called a rights agreement and a stockholders agreement, as well as the certificate of incorporation. When you take money in a venture capital round, for instance, in a C corp, you amend your certificate of incorporation and you end up adding preferred stock, and the preferred stock has a whole litany of rights and preferences. They'll have dividends, and they'll have liquidation priority on liquidation, and control rights in terms of what the company can do without a particular percentage of them agreeing to it. So your certificate of incorporation can go from 1 page to 20 with one funding, and rightfully so. As I noted, it's really, I think, one of the key things that you need to have right at the outset is a good form of offer letter with an associated confidentiality and assignment of inventions agreement. Thinking about if you're going to do if you want people not to compete, if you have some really key contributors, in particular if they're customer facing and you think a non-compete is appropriate, they have to be reasonable in time and scope, duration, and tied to a legitimate business interest. And they have to have separate consideration. So an offer of employment is sufficient consideration in most jurisdictions. Doing it after employment without any additional continued employment is not sufficient consideration in several jurisdictions. So you want to do that right at the front end if you're going to be asking people not to compete after they leave your employment or your engagement even. And then, as I noted, non-disclosure. Bilateral, meaning you're kind of a mutual, or unilateral, where you're just saying, look, my stuff's really special. If you want to look at it, here are the requirements. And you just assume. That's what I like to do for most clients, is to say, you can use a unilateral one, because if you really think about it, when you're mutually sharing confidential information, and if you're not marking it, who knows? At the end of the day, if you're going to fight about it, it's going to be a mess. So ideally, if you can just say, here's my NDA, all my stuff I give to you or say, whether I mark it or not, is mine, is best for you as the company. And sometimes you can get that, not always. Marking it's great for clarity, but I know it's not realistic in many circumstances. So I've run through a lot today. I want to thank you all for your attention and for your ability to participate, and I'd love to answer any questions you have.
Anyone have a question they want to start off with? Bob? Oh, I thought you put your hand up. Yeah, David.
Hi. So it's more of a personal thing. What's your favorite part of what you do, like your day, and you enjoy most? And then on the other side, what's really frustrating for you in your day, or like what's in your inbox where you're kind of like, I'll get to that later?
Oh, that's interesting. I love solving problems with companies and, helping them find a path forward. So kind of as a general matter, when someone calls me with something new and they don't know what to do, I think because I've had a broad background in a lot of different areas in the corporate world, I'm able to help them find a solution. So whether that's in terms of figuring out how to negotiate a particular term with someone, or how to figure out an exit for someone who has to leave in a way that's mutually compatible, problem solving is the favorite thing that I do. I really feel like I'm really contributing to the growth of their company and helping a person with the problem. I think at the baseline, a lot of lawyers in the transactional part of the world, not the litigation, we like helping people. It's like we feel like we're adding value and we get to be a part of their company. And that's, I guess, as a corollary, it's really fun being at the front end of new stuff. It's exciting, and you see the enthusiasm and the incredible intelligence and breadth of knowledge that these, you guys all have, that, we're just different. We don't have that necessarily, that creativity, or that certainly the scientific or technical knowledge. So that's my favorite part of the job, is working with entrepreneurs and helping them solve problems. My least favorite is having to answer the same, address the same problem multiple times with the same client. Because it gets frustrating when you're doing the work and you're trying to get them on the straight and narrow, and they can, consistently feel like it's just not important. There is obviously, I think you see this. People joke a lot about the lawyers. It's. But you know what? We're trying our best to keep you guys out of trouble, right? So that you can do what you do. And when folks just say, "Okay, I'll sign that," and then they don't think about what happened and they just do it over and over again, that I get less. I get less pleasure out of.
So before I hand over the microphone to our next question, I just want to say I can attest to Karen's ability and interest in doing this, because I was first her client before I became her friend. We were introduced by a mutual friend because I was dealing with a problem with a venture capital group that I was working with, and it was a hornet's nest.
Right, which you would never have imagined, right?
No, never imagined. And these were high caliber, high end, white shoe lawyers, and the mess that they created was breathtaking, and Karen single-handedly dug me out of it and saved my deal. So that's how our friendship began. So please, your question.
How do you protect yourself? You're going into a startup with a partner. Have you seen cases where one partner takes the idea and just runs with it, and kind of leaves the other partner hanging? And how can you kind of mutually protect yourself going into a startup with someone that you might do 50-50 or 51-49? How do you protect yourself? I've definitely seen circumstances where there's a real misalignment of expectations between partners, where people think they're people think everybody thinks what they're doing is the most important thing, right? They think what they're doing is way more valuable than whatever their not everybody, but oftentimes you can see that. So the best way to address that is if, for instance, if you're doing a limited liability company, you do it right when you're filing, and you're both, the managers, you're signing up as a manager-membered entity. In your operating agreement, you address that. You each have your interest. You say, this is my interest, and then, I'm gonna, you each delineate and allocate who owns what in writing, so there's no ambiguity. The code will if you don't say it, the code's going to assume it's equal, but it's always best to be clear. And then who gets to vote on what, right? Because oftentimes it's the economic interest and how you might, if your partner doesn't continue to perform or participate, how do you get it back, as I mentioned earlier? Or, how are you going to agree on dilutive issuance? A whole host of things. Like, how are you guys especially if there's just two folks, how are you going to agree to move forward? So I'd say a lot of those things, when you work with a lawyer to develop your operating agreement, you go through that. There's a huge checklist that I walk through with founders around a table, and we talk through these issues to develop something that's a working document. So for the most part, when you do deals, or start companies and you do these initial documents, they go in a drawer and you don't really think about them. And you only think about it when you have a problem and you pull them out. So it's my job to help build something that is as robust as possible that address those things. And I try to address them with people around the table right at the beginning when everybody's feeling positive. And I have, even this, in the last year, there's been one where I sat there, we all went through this, and not 6 months later, 2 won out, because the person wasn't performing as they thought. And we built in, okay, well, it became less personal because we already had outlined, well, how does that happen? It's never great, so there's always a personal component and disappointment, of course, but that's how I would recommend it. Doing it in writing at the outset, and with clear expectations about roles, and like who's going to be the officer, who's going to be the CEO, who's the chief scientific officer, and what are the roles. So the more specific you can get, the better, to avoid those issues.
Adam.
Have you seen common problems with people who start companies who are on visas, technology visas? Is there a particular, and then, let's say their immigration status has a problem, but yet they're trying to move the company forward?
Well, I'll say that I had clients who have been on visas, well, they've all had status. They weren't on temporary visas. So I haven't had any founder clients who've been on temporary visas, but I am aware of it. I'm not going to be able to give you the right data, but there's a green card fast track if you put $500,000 into a company. And I am aware, I'm actually just getting involved in something like that, so I can't speak intelligently about it at the moment. I don't know enough. But I would say that as it relates to, I think it becomes an issue. I've seen issues, not issues, but concerns about when you have like postdoc students who are participating in the company and you're giving them security, you're giving them securities. You have to have you kind of put in black and white, like you are not opining or representing about compliance with any other jurisdiction's laws and whether that's, available or for those individuals, because that's just too costly. I mean, people just don't do it. So, but I can't say that I really haven't seen founders who are on temporary status who then have an issue.
What is the biggest complaint that venture capitalists have in their funding rounds when they're looking at the due diligence and the documents of the startup, and they say, this is horrible? What's the one or two things that you've seen?
I would say the two most common things are, one, when they ask for a cap table, a capitalization table, a term of art, is a listing of every shareholder and their percentage interest of the company, both on a actual basis, meaning what's outstanding, and then anything you've promised through an option plan. One is the fact that the connection between it doesn't exist, that people look at you like, they have their eyes glaze over at the angel level. They don't know it. I mean, by and large, I'm the person who's creating those for companies, particularly when you have scientific founders. And the documentation, so you have, or even when you represent, okay, these people own it, and they say, okay, let me see the subscription agreements, and they go, what? Or where's the option agreement? Where's the equity comp plan? Did you have it? And they don't have them. They made, a lot of times what you'll see is that people make promises in consulting agreements for options, and then they never do them. Well, it's still, so what you have there is a kind of contractual right that individual could enforce in the courts if they wanted to, through, for damages or specific in performance. And you have then you have kind of a diligence issue for funders. So I would say the lack of documentation or consistent documentation related to ownership of who owns the company, because that's so important, and then IP related issues where they don't know, like they don't have, they're representing that they have assignment of inventions from everybody, or they have this certain amount of rights from various parties who've contributed, and they don't. And then you have to go back and hire. At that point, you're hiring a patent firm or a big firm to fix that. Usually, I mean, in many cases. Sometimes you can go back because it gets more, the further along you are, the more expensive that becomes to fix. I would say, and then generally speaking too, I'll say the other thing I hear a lot about is that there aren't, the lack of strong business development and this is more angel than VC, because it's very early stage where you have, you're presenting your plan, and because you have a small team, but you don't have someone on the team. You've got the scientific team locked and loaded, but you don't have a strong business partner with you to help navigate all this stuff, keep track of all this stuff. And I think that's probably so a lot of times that doesn't happen. So I do hear a lot of complaints about that and the lack of people in this market to do it well, for the right amounts. So business development is art and science. You really need deep, credible relationships. Everybody's networked. Everybody knows who everybody is. It's a small community, relatively speaking. But for someone to actually get something done, there's only a handful. And I've worked with some great ones, and they're serial entrepreneurs. They work for multiple companies at the same time, and then they move on, and that's what they love to do. But then there's a lot of folks who come out of pharma, who think that because they worked in business development in pharma, they can do business development for a startup, and they're very different. When you have all the money, everybody wants to meet with you, right? It's very easy to when you're on the other side, you find out how strong your relationships are. And I saw this at Safeguard too. This is a little far afield from your question, but when we were at Safeguard in the late 90s, and we were, starting all these various biotech and technology companies, we were hiring all these folks from GE and IBM and, Xerox, big companies. Well, folks who work in big companies are used to infrastructure, and other people doing for them. Early stage, you need to be able to you want people who will get their hands dirty. You have to. And whether that, you can't have prima donnas. And I think some folks like pedigrees, and they look a certain way, but they're often ill-suited for the early stage world. And so I have seen a lot of mistakes at a little later stage in companies where they're like, oh, this person looks like a rock star, look at their resume. Well, they've done it in a different context, and they're really not, in my personal experience, terribly transferable. Sometimes, but not often.
Any last questions before we break for lunch? Anybody? Or is just the sound of the word lunch at this point so appealing? Well, for those of you who are joining us for the first time, we end by heading over to the Jazz. Karen will be coming over, and if you think of a question that you should have asked, you'll have a chance to ask it there while you have a cup of soup. I regret to say that we are not having carrot ginger soup today, but we are having tomato bisque. Carrot ginger, for those of you who don't know, is a big hit around here. Karen, thank you so much.
My
for
great pleasure.
amazing
Thank you.
presentation.
Thank you all.